earlier, my lord, your lordship not be able to take it up, my lord. If this can be listed, my lord, at least, my lord, on Monday, my lord. I have already
Rejected.
My lord, may I have my lords kindly to mention the matter, my lord? I wouldn't have mentioned the matter because of urgency.
It's not mentioning date.
I know, my lord, but because of the urgency, I'm mentioning the matter, my lord. On the 24th,
Roster. My roster or just a Senate roster?
sorry, it's an upgradation of the list of Honorable Justice Amrita Sinha.
Upgradation.
Upgradation. I tell you, lordship, why on the 29th is the date fixed in the lower court on the basis of a false report, false certificate, which is under challenge before your lordship. They sought for injunction. On the 22nd, taken up by the lower court, and the lower court said that if you get the order done away with, otherwise I'm going to pass an injunction on the 29th.
Let them pass an injunction. You
That will be an injunction. Your lordship knows I cannot get out of the.
Please, may I
Any fixed upon any day, my lord, for 30th, my lord, any day.
No
Lordship,
upgradation.
kindly to mention one writ petition, my lord. My lord, we are the supplier of railways. My lord, we had supplied them a quantity of more than 2 crores. Now, there is a specific provision that whenever the amount will be deducted, a fair hearing shall be given. Out of the 2 crores, my lord, more than 1.25 crores has been deducted from my
Before the roster bench.
My lord, I am losing every opportunity.
Go before the roster bench, sir. Yes. Yes.
Number 3 subject fact and having each application for Honorable Justice Subhashani Bhattacharya. The right back and interest of the property is pending before Raj and Civil Judge 4th Court Junior Division Alipur. He also suppressed fact the right on possession of this property is also pending on the same court. He also suppressed fact the learned district judge interpreting government's policy on refugee rehabilitation department, where refugee rehabilitation department did give it. The person give it in favor of a person. That person, his brother, sister, cousins would be entitled to this property. My lord, he on the one hand, he was for give it. On the other hand, he was for allotment. With the expiry of his father, there was no allotment at all. He suppressed all these facts. He did not give me as a party. He did not sub-petition. He got order from Honorable Court. Honorable Court pointed out, directing the government official to call for personal hearing. And personal hearing was taken for cogent decision. I was called to attend before personal hearing. Seeing the record, government official called us for personal hearing. He followed ill path to grab the property following violence. Under the circumstance, an application under section 107 was also pending before London Executive Magistrate Alipur. That apart, he was using men for measurement of the property. Government official did not take cogent decision within the requisite time. Now they communicate to us that they would take cogent decision on sole model of Honorable Court and Learned Court. As he is following a policy of disturbing me relentlessly, let the matter be listed and let the matter be taken up.
Before the roster bench. Yes.
Kindly pardon my impertinence.
Yes,
My lord, my interim order is expiring on 30th of April. My lord, upon notice I am mentioning it.
May I permit to mention, my lord?
Yes.
My lord, an extreme urgency matter has allowed the writ petition to be filed yesterday, and the writ petition is appearing today as item number 31, my lord. My lord, on 28th, they will be coming and taking position from me and outs me from the position. Again, I am not notified, I am not at all involved in such transaction which has happened with the third party with the bank. My lord, it is item number 31 in today's list, my lord. My lord, if it can be fixed, I have served to all the respondents and they have obtained service also. My lord, if at 2 p.m. my lord kindly fix this matter.
Not today. Not today. I can't.
My lord,
Then at 2 p.m. I come back and mention.
Don't come at 2 p.m. Yes. Yes, Mr. Bhattacharya.
One matter of Justice Sinha.
What is the reason? Any urgency? What is the extreme urgency, Mr. Bhattacharya? Tell me what is the extreme urgency?
Extreme urgency, Justice Khan.
No, no.
Malada,
I want to Mr. Sen.
may I am sorry, Malad, I am on the virtual mode, Malad. May I mention, Malad, this matter, Malad? But kindly see, on my complaint, there is an order of demolition which has been passed by the corporation. There is no dispute about it. They have recorded that there is no sanction plan at all. Now, corporation, Malad, your lordship knows for any reason, they are just not doing implementing the demolition work. I have filed an independent writ petition. Well, kindly allow that writ petition, my lord, to come up in your lordship, please.
Mr. Sen, what is the urgency?
Ordinarily,
What is the
urgency is, my lord, I have got a sanction plan for construction just
Both of-
just on that same plot of land. And if I start the piling work, then that building will definitely collapse, and will result in local unrest. This is the difficulty, my lord. I have a sanction plan. I cannot start construction.
You are the neighbor who has a sanction plan.
I am on the same property. I am on the same property.
You are in the same property. If you start your piling work, what will happen? Piling,
The other structure which is on the part of this property will collapse.
why will it collapse?
Because it
Piling
is a
work doesn't need to collapse of structures. Every house, there's a piling, there's a pillars which are put and
no,
then.
no, but
structure
because
comes up.
that structure which is standing today, that does not have foundation. It is just a structure which is made.
Wait, Mr. Sen, let me hear Mr. Bhattacharya.
Yes.
This petition which he is mentioning is at the instance of the complainant. I am mentioning the petition at the instance of the accused person who has undertaken illegal construction. There is an order passed by the municipality to demolish it. He has questioned the order and has filed a petition. No steps taken. It is at our instance that the matter was listed before your lordship. It is 262. Now, what difficulty we are facing is, the illegal construction is only portion of a land, not the entirety of the land. Now, if today, piling work and everything is undertaken, then local unrest has already taken place without spotting the construction process. There is no embargo to construction. No order of any competent court of jurisdiction has passed any order restraining us from undertaking any construction. But the moment we take steps, local people are barging in, preventing us from undertaking the construction. What I was humbly beseeching your lordship, Mr. Sen has filed an independent petition. Let it be listed along with 262. That is my only humble prayer to your lordship.
Mr. Sen, today is not the mentioning day.
Sorry, my lord, I've taken this indulgence, but kindly give us some precedence on any day convenient to your lordship.
Mention it on Monday, we'll have it on Wednesday.
Very
well. I shall do it. I shall. I'm sorry, my lord, for disturbing your lordship, my lord. Sorry.
Monday.
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 Very
You mention on Monday?
Malad,
Folded, with folded hands.
Mr. Justice Sinha will be back.
No. Next 5 days, my entire lock, stock and barrel, my entire investment is with the bank.
Nothing will happen. Everything will come back. Everything will. This Monday will see.
Malad, in a complaint circus, Malad, may I permit to mention file Malad this matter, Malad, regarding Malad Justice Sinha's bench, Malad.
What is the urgency?
Urgency is that Malad, my client Malad, taking loan from bank, Malad.
Very good.
Banking authority, Malad, going to Malad take over this
Go before the DRT.
residential place because
Go before the DRT.
no, that is not the issue, Malad. Issue is that Malad, my major portion of deposit made to the Malad government authority.
Very
Security.
good. No,
Can I
sir.
take it? Can I take it up, Malad?
No, sir. No.
Kindly grant me because
No
30 is the
urgency.
date for
Ms. Sinha will handle.
Malad.
Ms. Sinha will handle.
Malad, kindly take it up.
No urgency, sir. No urgency.
Malad, urgency is that 30 thought Malad taking
urgency.
position my house, Malad.
Nobody is going to take
Position of
possession
Malad
of
bread and butter and right to property, Malad.
If your house is taking possession, go to DRT.
Malad, DRT is not the authority, Malad, because Malad, my security
Proceedings are what? Section 14 proceedings?
Malad, security deposit is Malad,
What are the
deposit to the government
proceedings?
authority,
Sir?
Malad.
What are the proceedings? Section 14.
Proceedings, Malad, that is true, Malad. But if I give the money, Malad, that all the Malad,
All right. You can recover it later. Yes.
Which time has been given for election date or one day long? Not taken up, Lordship. I have to be elected by the jailer.
2 weeks time.
Time was given.
How many times you have been given 2 weeks time for eviction? Unauthorized construction.
Two time matter of I mentioned earlier that
Yes.
will be going to evict.
Railway authority will do nothing in 2 weeks. Yes. Nothing will happen, sir. Nothing. You take it from me, nothing will happen. Yes.
My lord,
Yes.
my lord, may I be permitted to mention one matter? The petition is the de facto complainant in,
Which group matter?
my lord, before Justice Amrita Sinha.
Yes.
My lord, the petitioner is the de facto complainant in the criminal proceeding arising out of Calcutta PS case number 571 of 2014. Due to the negligence on the part of the special public prosecutor, the charge has not been framed till date. Hence, the petitioner has prayed for appointment of special public prosecutor. My lord, kindly fix a date.
Madam, there is no urgency. Go before.
May I have your lordship leave to file a writ petition before with the Justice Sinha's determination. Your lordship, the urgency is that the victim petitioner is a victim of a sexual assault, which resulted into an unwanted pregnancy. And lordship,
When did the petitioner became a victim of sexual assault?
your lordship, on 4th of December 2024.
4th December, right? And then
Your
what
lordship,
happened after that, madam?
Your lordship, FIR was filed on 30th of March
What do you
2025.
want today?
Your lordship, the pregnancy is currently of running approximately 25 weeks. Your lordship, the petitioner wants for the termination of the pregnancy. So praying before the this bench to hear the matter out and grant the permission for the termination with the
She's 25 weeks pregnant
yes, lordship.
and it's a fresh petition.
Yes, lordship, it is a fresh petition.
Take it.
Your lordship, if that it could be fixed today for your lordship.
Not at all. Tuesday.
Your lordship, if it could be fixed on Monday, lordship, because
Tuesday, madam.
My lord, permission to mention one urgent matter, my lord. My lord, this is in relation to unauthorized construction, my lord. Subsequently,
No unauthorized construction
my lord,
mentioning today.
unauthorized construction of a, my lord,
Let it
hotel.
come up, sir. Very good. Unauthorized construction, very good. Let it come up. It will get demolished in accordance with
Certain
law.
developments are happened, my lord. He's a
Very good, sir. Today is not the mentioning day.
My lord, may I mention one matter from the list and determination of Honorable Justice Amritsar Khanna.
Yes.
The petitioner's passport has been impounded arbitrarily without giving any opportunity of hearing by the passport authority.
Good.
My lord, the petitioners moved several times before the passport authority.
Very good.
But his
When was the petitioner's passport impounded?
my lord, in October 2024. But the 6 months leave is almost going to expire. Only 18 days is left, within which if he could not join his work abroad, my lord, he will lose his job.
Very good. He has waited for a long time. He can wait for one more week. Yes.
Liberty to make that one writ petition during pendency, during hearing of the writ petition, my client found that his trade license cancelled. Now, from there, I appear before the appeal court.
This is,
No, my lord, there's a little bit short story. Otherwise, my lord, I cannot
madam, this
explain.
is what?
my
Group 9?
Yes, group 9.
Yes.
Now, from that, I filed two writ petition, different. One pending before your lordship, being serial number 2534 in the monthly combined list. Another writ petition I filed challenging to the police in action to not to open my shop room, since there I have a valid license. The initial writ petition cancelled my trade license. Then and then I applied for the fresh one. Fresh one was issued. On that trade license, I placed before the police and asked allow me to open the court, because initially there is an order to close the shop room. Now, during pendency before Justice Titankar Ghosh, your lordship found, since the matter pending before your lordship, he cancel the earlier trade license. Your lordship released the matter and placed before your lordship. I mentioned before the registrar, the department mentioned, since the matter already placed before your lordship, you must mention before your lordship to tag the matter. And since the shop is stopped,
The matter has to be marked by the honorable.
Seek the matter Monday or Tuesday.
Madam, the matter has to be marked to me by the Honorable Chief Justice. It has not
No,
come to me.
I already approached before the registrar.
Madam, the information has not come to me. This is not how it is done. If an honorable court releases a matter, the matter goes to the Honorable Chief Justice. He will mark the matter to this court. That exercise has not been done. All right, you go and follow up with the Chief Justice's office. If you have mentioned or you're not mentioned, I don't know.
I mentioned there.
If you mentioned,
submit the letter there.
you
but
follow,
they mentioned
you
the
follow up
file
from
already
there.
been placed before your lordship.
It has not been placed before. You follow up there. All right.
Assigned to
your lordship, if the leave could be granted to move in on Monday, lordship, at the top,
Tuesday, madam.
lordship, Tuesday on the top of the list, lordship.
It will come up on Tuesday. Call out the regular matters.
original side matter, item number 1.
This is the original side matter.
Our instructor to the issue of the pathway on this is from the asset loss. Then was taking the matter jurisdiction concern. As the date is 15 January 2025. But directing the claims not to take any courses taken. Subsequently, the order was extended by Honorable Justice Hiranand Bhattacharya by order dated March 27, 2025. That is, as I had already indicated, that is still
End of April.
April 30, 2025. But by the time the next week, the matter will be taken or extended. 30th of
You have not filed your,
they have filed the report directed us to file a report. That report has been filed, to which they have taken an exception. And the exception is ready, Malan.
is the report there?
I have filed the report.
Report is there?
They are taking 2 extensions, they have filed the report. Coming with our extension.
We can decide it.
Lordship decides it. The exhibit
This,
to the hearing matter.
which, this is my board or?
No, yes, your lordship's board. Your lordship's board.
What is this matter all about? What is the matter all about?
The matter is related to an auction purchase before National Company Law Tribunal, I was the successful purchaser, the sale was confirmed in my favor. I had put in the entire consideration price. Thereafter, I was called upon to payment the transfer fee, GST, everything. Now the property was even registered in my name. Now, as the procedure of insolvency, but the insolvency resolution professional, every claim, every unsecured claim, every claim whatsoever was called upon. Every unsecured creditor went there within the stipulated period. This KMC, they did not approach despite giving the public notice, everything, they didn't approach for their money whatsoever is claimed. Now, after the similar, yes, there is a twist over here. Twist. The purchase was on the basis of as is very basis and no recourse basis. And today Supreme Court has delivered a judgment. And our division bench of our court has interpreted that judgment. So let us hear it out. We have to approach the law, then the Supreme Court judgment. Yes, of course, yes. You have also to see the things. Yes. Yes, yes. There was no such condition imposed in the sale condition notice. That is not my headache.
Take
Go
down.
before the fancy hibernation.
This court by order dated 15 January.
It's not my headache.
The first order is 15 January.
Yes, madam.
This court by order dated 15 January had granted an interim stay, full stop, which was further, the interim stay, which was subsequently extended by order dated February 12, 2025. February order is?
February order is 27th, the March order is 27th March 2025 by Honorable Justice Bhattacharya.
Was further extended so the same order was further extended by order dated 27th March 2025 till what? Extended by order dated 27th March 2025 till the end of April 2025 or until further order, whichever is earlier. Full stop. Let the interim order be extended till May 2025. We'll finish it. Before that, we'll finish it. I'm keeping the matter before.
Summer vacation, I will be ready with the matter if he starts.
Mr. Mukherjee, I want to finish that matter and then I'll have.
That will not have any impact over here. That's a different thing. This is a different thing.
Till May 2020
Not the auction purchase.
or until further order, whichever is earlier. Let this matter be listed for hearing on. Let us keep it for hearing. Pleadings are complete, right? Pleadings are complete. Wait. Today is. Keep it for 1st of May. 1st of May.
May 1.
1st May.
May 1.
No, that is original side day. Sorry. This is not original side. This is original. 1st of. Will
At the top, my lord, if you love it, I'm reading to love it, my lord.
1st of May. Top 5 matters.
Yes, if you.
We'll finish it.
Grateful.
Item number 2.
I'm extending the order till 15th of May. Till May 15th. May 15th kar dena. Order is extended till end of May, May 15th. I'll finish it off before. Yes, Mr. Banerjee.
My lord, before the petitioner, I am appearing on behalf of the successful auction purchaser,
Yes.
Maithan Infrabuild Private Limited.
Yes.
But I have not been served with a copy of the writ petition. I do not know. I don't think even I'm a
Maithan.
my lord. I don't.
Is item 2 or which one is this? In one, he has not.
My lord, in the first matter, my lord, we came to know that, my lord, the bank must be knowing, because, my lord, our cases, my lord, that
But
there
which
also
item?
Successful purchaser, my lord.
In which item? The
My
link.
lord, item number 2.
Maithan Alloys Limited.
Maithan. You're a
Item number 3, my lord, we are not aware of. Item number 2.
All right.
My lord, I am the successful purchaser, my lord. I have a vested right in my favor.
Wait. Don't worry. Yes.
But,
But I am for the respondent number 1 and 2, the bank.
Yes.
my lord, the
Yes.
case, yes, my lord, the case is this.
Lord, I am
Lord-
raising the maintainability of this application under Article 226 of the Constitution, because it is a surfacey matter where the sale was conducted, and, my lord, there are several judgments of the Supreme Court, latest judgment also. It provides that since the efficacious remedy is available. Well, that is my preliminary objection.
But sir, he is neither the borrower.
Yes.
No, they are not the borrower.
Then how will he go to?
They are not the
Exactly.
borrower. They are an interested party. So any interested party, my lord, section 7. Any party.
I'm grateful to my learned friend, my lord. He acknowledges me as an interested party. Then, my lord, may I maintain my writ petition on that ground?
My lord, I have a right of audience, my lord.
Stay.
Let me first move my writ petition.
If
The
I-
anxiety shows, my lord, that
If I need you, I'll let you know.
Very good. Very good.
Yes.
my lord, this particular, my lord, property, which is, my lord, industrial land, my lord, along with plant and machineries.
Yes.
My lord, there were first notice, my lord, was given, my lord, with regard to this, my lord, as we found, my lord, from the papers, 11th August 2024, which is, my lord, page 46.
Yes. That's the first notice,
That's the first notice.
which was recalled.
Sorry, my lord.
Which was recalled.
Yes, correct. Financial Express,
Yes.
Union Bank,
Yes.
then, my lord, this gets, my lord, withdrawn.
Yes.
Page 47.
Yes.
Then, my lord, another notice at page 49. This is, my lord, the second notice. This is, my lord, on 8th September 2024.
Yes.
Now, no sale happened.
Yes.
Now, third notice, my lord, which is, my lord, after a gap, my lord, of about 5 months, on 15th February 2025, are, my lord, in some very obscure papers.
Yes.
Paper called, my lord, Echo of India, Kolkata.
Their circulation is more than the Financial Express. Do you know this?
Sorry, my lord.
Their circulation is more than Financial Express.
More than Financial Express.
Yes.
My lord, not in Calcutta, my lord. It's Echo of India, my lord, Kolkata.
Yes.
And, my lord, the other one, my lord, is Arthik Lipi, which is, my lord, the vernacular.
Yes.
And then, my lord, there's a single bidder. And then, kindly see, my lord, when we wrote a request for information,
Yes.
page 52,
Yes. Yes,
To the authorized, my lord, this is April 16.
yes.
We write to you in connection with the immobile property, plant and machinery located at Salanpur district, West Bardhaman, which stand mortgage in favor of Union Bank by the borrower Chhabra Ispat Private Limited. Come to our attention through various sources, that an auction of the aforementioned secured asset was conducted on 20th March 2025. We note with concern that no prior notice of communication was issued to us in this regard, despite our continued repeated requests to be kept informed of the auction schedule, particularly after the earlier auction dates were deferred. As you're aware, the auction was initially fixed for 13th September, subsequently rescheduled to 9th October, as notified through public advertisement in the Financial Express. However, both these auctions were postponed with an assurance that a revised date would be communicated in due course. Pursuant to the same, we have been continued correspondent follow-up with your office, specially requesting to prior intimation of the next date of auction, given our expressed interest in participating as a prospective bidder. To our dismay, no such information or public notice was shared with us. We are now given to understand auction purportedly held on 20th March was conducted without adequate public notice, seemingly without adherence to the principles of transparency and fairness, thereby denying us a reasonable opportunity to submit a bid. We are the above, we respect call upon you to furnish complete details of the auction proceedings held on 20th March, including mode and manner of publication of the auction notice, provide copies of all relevant documents, including sale confirmation letter, if any, issued in favor of the successful bidder. Pending such disclosure, we request to stay all further proceedings with respect to subject asset and give us a fair opportunity to place our bid, which we are sure shall reflect the fair market value and assist in maximizing recovery of the bank. This communication being issued without prejudice to our rights and remedies available to us, law. Then, my lord, can you see the reply which they gave, my lord?
Yes,
Page 53.
yes.
In regards to trailing mail paper publication regarding auction of the caption, property was held on 15 February in the following newspapers: Echo of India, Arthik Lipi.
Yes.
And my lord, that's my lord, all they gave us. And my lord, and
1.5 lakhs financial.
my lord, you can put that on if my lord wants. My lord, Echo of India, my lord, has, my lord, in Calcutta, my lord, about 21,000 readership. My lord, we can put that, my lord, on record, my lord, if my lord
No need.
wants us. My lord, two things, my lord, are very important. First, my lord, if it went in Financial Express, then it is withdrawn. 9(6) requires, my lord, publication in papers with wide circulation. And my lord, single bidder in February and given, my lord, to, so far as we know, this is the amount. And my lord, this one number 2. And my lord, the price was 9.85, my lord, was the reserve price, given at 9.95.
Which is the lowest incremental bid.
That obviously.
Yes.
So, my lord, that's the lowest incremental bid, my lord, which, my lord, could have been given. My lord, we have challenged, my lord, this, my lord, sale, my lord, to say how, my lord, this was done, my lord, surreptitiously.
My lord, if the sale is
And my lord, sorry, well, just one. So sorry, my lord. We are ready, my lord, with a higher amount immediately, my lord. We'll, my lord.
But first of all, it is not a private treaty. It is a public auction. Notice was sufficient, notice was given. And my lord, who will be the affected person? The borrower or guarantor whose property is being sold? They are not, my lord, objecting to the sale. They are agreeable to the sale. And my lord, the sale certificate was issued.
Yes.
And subsequent thereto, my lord, this my lord, email has been given.
Yes.
And my learned friends, allegations is the publication is not being made properly. And it is not. My lord, if I may say so, my lord, I have taken, my lord, Eco. The Eco time, my lord, in the West Bengal, my lord, Kolkata, English, Delhi, my lord, this circular is, my lord, 24,974.
Yes.
16.88 rate. 16.86 rate.
Financial Express.
And yes. My lord, this is Bengali RP Clippy. Yes, it is, my lord, the circulation is 24,993. 16.86.
And what is Financial Express?
My lord, my lord, Financial Express, my lord, Financial Express is, my lord, 15,765, which is less.
That's what I also checked.
Yes.
Yes. Yes. What?
So, my lord, now, my lord, my lord, I do not know the two applications. One application was filed before the Honorable Court, Honorable Justice Amrita Sinha. Then all on a sudden, no notice was given. It was appearing before your lordships, item number 65 and 66, 46 and 45. And immediately today, I am found that it is appearing as item number 1 and 2. No notice was given.
Perhaps,
No service.
I'm sorry, just to interrupt my learned friend, 3 notices have been given, including today's notice.
Doesn't matter, he is here.
So, my lord, I am handing over the sale certificate. My lord, this is the sale certificate, yes.
9-6, huh?
Yes. Sale certificate copy ta kothay? This is not
paper ta bar kore
That's what I have.
Il. Dekho okhane dekho kothay dekho. Yes. My lord, all formalities has been complied with.
Yes.
And my lord, if he is at all aggrieved by, I do not know, because sale has already been concluded.
All. Take down.
My lord, just one, my lord, in
Yes.
submission, my lord, in rejoinder. My lord, in page 53, my lord, when they respond on 16th April 2025, my lord, there is no mention of, my lord, this sale notice of 16th April. My lord, so far as, my lord, financial expense is concerned, my lord, financial expense is concerned, my lord, they have, my lord, a sale, my lord, of circulation, my lord, of, at least, my lord, according to us, my lord, 84,000 in Kolkata and 1,57,000, my lord, in total. And, my lord, secondly, my lord, I don't know whether, my lord, is looking at, my lord, both matters, because
I'm just looking at one matter right now.
very well. My lord, in this, because in the second matter, my lord, there is also communication to them in writing, asking, my lord, prior to sale.
The second matter, you have not even made the other.
No, my lord, in the second matter, we were not aware.
Right.
My lord, lawyers may be aware, but my lord, the party was not aware, my lord, so far as, my lord, it was sold to.
My lord,
You have to
Because-
make them a party.
now, my lord, if I may say so,
Party in
Yes, my lord, now that, my lord, we know, my lord, we'll make them a party, my lord, if...
that we'll keep it some other time.
my lord,
my lord,
I am showing the authorized capital of this company. 1 lakh of rupees.
we have some money, my
1
lord.
lakh of rupees. And there,
But
my lord.
If I don't know why the bank is resisting a higher...
Yes, my lord, this
My lord, I understand Mithun resisting, my lord, higher price. My lord, I don't know why, my lord, the bank is resisting higher price.
yes, it is available in the public papers. Notice was published, well circulated notice was passed for
So
sale
why
notice.
twice it was withdrawn?
Forward was not, my lord, aggrieved by.
Oh.
And bank has no legal obligations, my lord, to intimate.
Take down. The petition in the present writ petition is challenging the auction sale conducted by the respondent bank under the SURFACE Act in pursuance of third auction notice dated 14/2/2025, and also the sale certificate issued in favor of respondent number 4 in respect of the secured assets of
It's a different respondent who has been arrayed as a party.
We are not aware because they're not.
Don't worry, sir. Don't worry. Of MS Chabra Ispat Private Limited. Full stop. MS Chabra Private Ispat Limited defaulted in repaying the credit facilities availed from the respondent number 2 bank. Full stop. Hence, the respondent number 2 took measures under the SURFACE Act to enforce its security interest over the borrower's immovable property. Full stop. Immovable property, comma kar do, i.e. piece and parcel of property along with plant and machinery and furniture and fixtures situated at the industrial land area of 10.73 acres in industrial area in Khata number 612 jail number 26 having plot number 925 964 965 966 967 968 969 971 972 973 974 978 980 981 982 and 983 Moja Nakra Juria PO Salanpur District Paschim Bardwan West Bengal. Full stop. In furtherance of such measure, respondent number 2 issued first auction notice published in which is the first auction notice is dated what?
My lord, dated 11th August 2020.
Published the first auction notice dated 11th August 2024 for auction sale of the secured asset to be held on 13/9/2024. Full stop. The first auction notice was published in the Financial Express newspaper, English, and one vernacular newspaper having wide circulation in the state of West Bengal. Full stop. The first auction sale could not materialize as the respondent bank had withdrawn the said auction notice, wide withdrawal notice dated 28/4, withdrawal sale notice dated 28/4/2024. Full stop. The respondent bank published the second auction notice on 8/9/2024 for the auction of sale of the secured assets to be held on 19/10/2024. Full stop. The second notice was also widely published in Financial Express newspaper and a Bengali newspaper having a wide circulation in state of West Bengal. Full stop. The second notice also could not culminate into sale as the respondent bank had cancelled the auction sale. Full stop. The respondent bank issued the third public notice, which was published on 14/2/2025 in an English daily, inverted comma, Echo of India, bracket, Calcutta edition.
But it was published on 15th
And
February.
15th February. 15th
Notice dated 14th too, but it
15th
was
February.
published on 15th February.
And Artik Lipi, vernacular newspaper in Bengali. Full stop. In the said auction process, the respondent number 4 participated and the secured assets were sold in favor of the respondent number 4. Full stop. Further, a sale certificate under section 9(6) of the Security Interest Enforcement Rules 2002 was also issued in favor of respondent number 4. It is the contention of the learned counsel for the petitioner that he is interested in purchasing the secured assets, however, the respondent bank issued the public notice in a newspaper which does not have a wide circulation. Full stop. The first two auction notices were issued in Financial Express, whereas the third one has been issued in Echo of India. It is his allegation that the newspaper Echo of India is a less known newspaper and thus the said publication is in violation of Rule 8(6) of the Security Interest Enforcement Rules 2002. He further contends that the respondent number 4 was the sole bidder and hence there was no competition. Full stop. He also submits that due to lack of competition, the sale was for a price of rupees 9,95,28,500, which was just above the reserve price fixed by the bank. Full stop. Learned counsel for the petitioner further contends that the bank has acted in an arbitrary and malified manner in collusion with respondent number 4, for sale of the secured asset. Anything else?
No, my lord, that is. And my lord, yes, contention, my lord, I don't know what, my lord, was cited, my lord, with regard to that figures, 24,000 and my lord.
That is a publication figure.
That is a
publication
Learned
figure.
counsel for the petitioner also contends that the argument made by the respondent regarding the circulation of the newspaper, the circulation of Echo of India, Calcutta edition, is not correct and the same is less than the financial express. Learned counsel for the respondent bank submits that the said auction was in accordance with law and there is no malafide in publishing the auction notice in Echo of India, Calcutta edition, full stop. Rather, he submits that the circulation of the said newspaper is much more than financial express, full stop. Respondent number 4 had participated in the auction process and quoted the price well above the reserve price, and hence the sales certificate was duly issued to the respondent number 4 in terms of section 9(6) of the Securities Act 2002, full stop.
My lord, sales certificate has been issued. My lord, your lordship kindly see the name, Messrs. Mython Infrabuild Private Limited.
Mython Infrabuild Private Limited.
Yes,
Name
but
of
they are not made.
We were not aware because they have not disclosed to us.
No,
We
no.
thought it was Mython Alloys.
Four is another person.
You are appearing for Mython. Was issued in learned counsel for the respondent bank also states that the sales certificate has been issued in favor of Mython Infrabuild Private Limited, though the petitioner in the present writ petition has not made Mython Infrabuild Private Limited a party, but instead has made Mython Alloys Limited as a party to the present proceeding. Full stop. Learned counsel for the respondent bank submits that there is no malafide or arbitrariness in confirming the sale in favor of Mython Infrabuild Private Limited. Full stop. This court has heard the arguments advanced by the parties and has perused the documents on record. Full stop. The scope of the judicial intervention in the matter of auction sale is very narrow and limited. Full stop. It is well settled principle of law that a confirmed sale can be set aside only on the ground of material irregularity or fraud or any other fundamental error in the procedure of auction. Full stop. While conducting an auction sale, the respondent bank needs to follow the due process as enumerated under section 8(6) of the Securities Rule 2002. And in furtherance of the said sale proceeds, the certificate of sale is issued under Rule 9(6) of the said Act. Full stop. Combined reading of both the sections will make it clear that the auction notice was published in two newspapers, one in English having a wide circulation and the other in vernacular as enlisted in the Act. Full stop. In addition, the notice was also pasted at a conspicuous part of the immovable property, and the authorized officer also had uploaded the details and terms and conditions of the sale on the website of the secured creditor. Hence, in addition to the paper publication, notice was also affixed on the secured asset and also on the website of the secured creditor. Full stop. In the present case, the allegation of the petitioner that they are interested in purchasing the secured asset, however, they could not participate in the auction sale as the respondent bank had published the said auction notice in a newspaper which is having a much lesser circulation and he was not aware is not correct, since the respondent had shown that the newspaper Echo of India, Calcutta has a wide publication, more than 25,000, with more than 24,000 subscribers. Full stop. The respondent bank full stop. However, on a closer examination, it is evident that the petitioner was actually interested in purchase of the said secured asset. That if the petitioner was interested in the purchase of the said secured asset, it was not difficult for him to find out the details of the said auction sale. Petitioner himself admits that he was in touch with the officials of the respondent bank since August of 2024. The sale was done much later than the period. Full stop. Sale was done in which month? The sale was conducted in?
In 20th March.
The sale was conducted in
2025.
In 2025, March of 2025, much later than the period. Full stop. It is also the sale notice was also conspicuously published, pasted on the immovable asset, as well as the same was also put on the website of the secured creditor. Hence, it is not possible to believe that the petitioner was not aware of the said auction sale. Full stop. Learned counsel for the petitioner has failed to point out any material irregularity or fundamental error in the auction procedure. Full stop. The auction sale is already concluded and the sale certificate has been issued to the successful bidder. Full stop. In view of this, at this stage, this court is not inclined to exercise its discretionary jurisdiction to interfere with the concluded sale. There is no merit in the presented petition. The same is dismissed.
I'm deeply.
One thing, my lord, I hope, my lord, it's been, I did, my lord, that we are offering a higher price. That perhaps, my lord, has put that in, my lord.
जहाँ वो submissions है ना petitioner का, the petitioner states that he is ready and willing to offer a higher price for the auctioned property. Anything else?
My lord, no, I'm so grateful, my lord. That's the first matter.
Second, we'll have it on.
My lord, the second, my lord, only one, my lord, I just wanted to point out, there's letters, communication, my lord, which are on record with them, my lord.
You make the successful bidder a party first, then we'll hear.
My lord, kindly give us that leave, my lord, now that we know, my lord. We will kindly, my lord, give us leave to
Learned
amend.
counsel for the petitioner seeks to implead the successful bidder in the array of parties,
Which we have come to know now, my
be
lord.
done within a period of 1 week.
1 week. 1 week.
Within a period of 1 week. Try your luck there.
My lord, the email which was sent, my lord, it was 6 months prior to the auction. Last
Within a period.
last
You sold it 6 months
As
after
this
the
matter will listed
email.
before the roaster bench.
deeply obliged.
One here, one there. Mr. Banerjee.
I'm sorry, my lord.
One here, one there.
It has a 3 and 4. Idiot.
Great.
Item number
I'm
3.
deep. 3 होएगा। 2, 3 होएगा। चलो। I'm deeply obliged. Deeply obliged. First order का वो item number 3 थे। हाँ।
उसमें एक वो जो है ना, जहाँ रूल 8 और 9 लिखा है ना, ऑन द प्लेन रीडिंग ऑफ रूल 8 and 9 लिखा है, उससे पहले रूल 8 और 9 कोट करो, ठीक है, कोट करो, just before that, just before where I stated ना, after plain reading of rule 8 and 9, वो You have the act. And got it? Any problem? Yes.
I appear for the respondent.
Yes.
Well, order has been passed by the Metropolitan Magistrate, Malad, in exercise of a Chief Judicial Magistrate in exercise of a power under Section 14(1) for taking up the physical possession and appointing the commissioner. Well, the date has been fixed for to execute the order. Well, the bank has chosen not to execute the commissioner and bank has chosen not to execute the order within that stipulated period.
Date was fixed as 22nd of March, 2020.
22nd of August 2020.
August.
22nd of August. Well, they were supposed to, well, if your lordship kindly takes up the brief once more, well, they were supposed to complete it within 22nd of March 2024. And the order was passed on 22nd of August 2023. So, Malad, within that period, they didn't execute the order. Subsequently, we approached before the tribunal, obtained a stay order. Subsequently, appellate tribunal vacated the stay application. Now, the commissioner had put us under a notice, Malad, saying execution of this order within a stipulated period of time. Now, our contention was that the commissioner cannot execute this order now without the date being extended by the magistrate. This is one, and the second I will submitted before lordship. The 14(1) application was filed by the same advocate who has been appointed as advocate commissioner. That is a nexus. That is a malpractice. The notice of the commissioner, as it appears in page 52, it's a violation of natural justice and malafide practice on behalf of the commissioner, in our opinion. This notice should have been, prior to sending this notice to us, the commissioner should have approached before the magistrate, get the warrant, the date of execution of the warrant extended, then and then only he could have sent it. We have challenged only this notice. So for the parental order and the order of the tribunal and order of the appellate tribunal, we have not challenged this order because this writ court is not the forum for challenging that order. We have taken a step already to challenge the order before a separate proceeding.
So your first ground is that since the time
That
which
the
was
page
given by
50,
the
52
CJM had expired, so that has to be extended. A fresh
time has been
application has to be
expired.
filed. The second
Within that
ground is-
period, bank has chosen not to execute that order.
That's the first ground. Second ground is
Second
that the
ground,
advocate is the same.
the advocate who has filed the 14(1) application filed the application before the appellate tribunal and the application under section 14(1) before the
The same.
are the same as the advocate. These are the
These two.
two grounds. I have covered by judgment.
You have given that judgment of Andhra Pradesh.
On that day, I couldn't give the reference of the judgment. Today, I have got a print copy.
The same Andhra judgment.
Same order, same, but
Citation.
that printout, there was no reference.
Yes.
That is why I've given it. And so for the reference of Supreme Court order on the same line, I have that is referred in that judgment. I have referred on the other day.
Yes.
Paragraph 6, sub-para on the last. Paragraph, if your lordship kindly sees, paragraph 6
The Housing Development Finance Corporation. Supreme Court, Citadel.
Paragraph 6 subpara. The essential component of
Citadel Fine Pharmaceuticals.
Malad?
Citadel Fine Pharmaceuticals. That one. 1989 3 SEC. That is the one you are talking about.
Malad, I couldn't follow.
The judgment which you are quoting, 1989 3 SEC.
Yes.
That's the
Malad,
one.
Malad, that this is
Which has been
no.
quoted
This is
here.
in respect of Government of India by the Citadel Finance.
Yes, that's what.
That order I also have, Malad.
Yes. Yes. Yes.
Malad,
Anything else?
Malad. That order. Malad, the taste is that Malad, the same proposition Malad cited here as Malad I presented before your lordship. We Citadel judgment.
Yes.
My lord, firstly, my lord, with regard to the issue of with the appointment of the my lord officer who is an advocate, I think my lord, he says that he has challenged the order of the DRAT, my lord, is taking steps. Now, this issue was argued there and it has been negated. So that cannot be my lord re-argued before my lord. Because he says now today itself that he's taking steps, my lord, challenging that order. So therefore, that was a subject matter of
DRAT order has already reached.
not so
But
that issue
I
will,
checked
my lord, I
the
don't need to
notice you
address. I don't need to address that issue with regard to appointment of the advocate, my lord, as they
You should. You address that also.
Very well,
because
my lord.
The document
My lord,
here, I can take notice of that.
very well. Now, my lord, the issue is that, may I just address that first? My lord, this issue, my lord, cropped up, my lord, they argued before the DRAT and they failed to show any documents that he was the
The
advocate.
document is here, sir. They are showing the document.
My lord, even if a document is there, there is no bar under the law that, my lord, he cannot be appointed. And if it is so, my lord, we are agreeable, anybody can be appointed. That cannot be a bar, my lord, for not, my lord, execution of the order passed by the magistrate. So we are agreeable, somebody else appointed, but there is no bar under the law, first of all. And this issue was taken and, my lord, they failed. The second issue is, my lord, is that this order that they are showing to my lord, kindly sees, my lord, the prayer. The prayer is with regard to the notice issued by the lawyer, not, my lord, on this order. The writ petition prayer, my lord, kindly sees once. That is a prayer wherein, my lord, is challenging, my lord, the notice issued by a lawyer. But that cannot be a subject matter of a writ petition. Because a question of maintainability would come as to, my lord, whether a notice issued by a lawyer can be, my lord, the subject matter of a writ petition. Kindly sees his prayer A and prayer B. He is not challenging the order per se. He is challenging the notice.
He's saying that the notice which has been issued by the lawyer is bereft of any legal sanctity.
That is what his submission is, my lord. But then he has not challenged per se in so many words the order, my lord, which has been filed by the magistrate.
The notice itself is void, illegal. Because it could have not been issued.
But, my lord, that remedy perhaps, my lord, he has somewhere else. My lord, I am not to tell him, but somewhere else. It fell from my lord also yesterday, I heard. Now, my lord, with regard to the order of the magistrate, the statute does not, my lord, say any time period for execution. And this is settled now by one of the judgments of this court as well as, my lord, by another high court, my lord.
Show me.
Yes. Now, my lord, kindly sees the judgment which he has shown before that, my lord, where, my lord, this issue has also been considered. My lord, kindly comes to paragraph 8 of his judgment.
The Andhra one?
Yes, my lord.
Yes.
Because this is the statute, my lord, the court cannot hold something contrary to it. My lord, kindly sees, my lord, at this stage, it would be appropriate to refer to another division bench judgment of this court in Korada Rajababu versus State of Andhra Pradesh. In the said case, the court was dealing with a warrant issued under section 70 subsection 2 of the CRPC. The main contention before the division bench in a batch of appeals was that warrants are deemed to be dead or lapsed. That's the issue, my lord, he is also trying to highlight.
if they are not executed within the time specified in the warrants or by the next date of adjournment. This aspect, which was not considered by the learned single judge, came to be challenged in writ appeals. It is to be noted that the court was dealing with the warrants issued under section 17 subsection 2 of the CRPC. After referring to catena of judgment starting from Emperor versus Malad, the whole lot of them have been referred to. Kindly sees Malad, the division bench of this court held as under. From bare reading of the guideline subsection D, the court must issue direction for return of warrant, whether executed or unexecuted on or before a specified date. When the warrant of arrest was issued under section 70 subsection 2 of the CRPC, it shall remain in force till it is executed by the authority, executed or cancelled by the competent court, or returned unexecuted by the police officer or authority to whom the warrant was entrusted. None of these have happened, neither has he complained of that. But in the instant case, the warrant appears to have been open-ended and no direction was issued for the return of warrants.
That is the distinction.
My lord, here, kindly sees the order.
Distinction.
Yes, kindly sees the order. It says, my lord, to file a report, not return of warrants.
No, the CJM order says the warrant has to be returned by 22nd.
Kindly sees that order. Kindly sees that order. I was also, my lord, trying to, my lord, find out. My lord, the order says to 22nd of March 2024 for compliance report. Nothing more than that. My lord, that's at page, my lord, I believe 59. Ours are not paginated, but my lord, I think it's at page 59. That's exactly what I'm showing, my lord. And all courts have dealt with this. 22nd March 2024
This is what it means, Mr.
for compliance report, not for return of the warrant. Now, this has been extended. Kindly sees the notings after that, my lord.
Yes.
The next, my lord, 22nd of March, 13/6/2024. Just below that, my lord, 14/9/2024. Then below that, my lord, 19/4/2025. And this has been again extended.
Yes.
So therefore, my lord, the warrant, my lord, even if I take that, my lord, a specific date has been given for, my lord, return, that has been extended. And that has not been enclosed by him before this honorable court. If the certified copies are, my lord, filed before the court, it would show it has got extended. It was last extended till 19th of April 2025.
Yes.
Now, my lord, therefore, this judgment, my lord, kindly sees, my lord, categorically says, my lord, is that the, my lord, date cannot be, my lord, fixed by the court or anybody, my lord, because this is, my lord, not there in the statute itself.
Yes.
My lord, may I just read that paragraph, my lord, my lord? My lord, kindly sees, my lord, this division bench, my lord, which has been quoted there.
Yes.
No direction was issued for the return of
Where
the
are you
warrants.
reading?
My lord,
Where are you reading?
my lord, this is the same judgment, paragraph 8, my lord.
All right. Yes.
That's, my lord, the division bench part which has been quoted.
Yes.
From bare reading of guideline 9, D, my lord. The court must issue a direction for return of the warrant, whether executed or unexecuted, on or before the specified date. When the warrant of arrest was issued under section 70 subsection 2 of CRPC, it shall remain in force till it is executed by the authority, executed or cancelled by the competent court, or returned. My lord, here the competent court had, my lord, has been extending it.
Read further.
Yes, my lord. Returned unexecuted by the police officer or the authority to whom the warrant was entrusted. But in the instant case, the warrant appears to have been open-ended and no direction was issued for the return of warrants or before the specified date, but directed the police to execute warrants to produce the accused on or before particular date. Thus, the date was fixed for execution of warrants, but not for return of the warrants if not executed. Kindly sees the distinction, my lord. Therefore, the warrants issued under CC number 350 of 2014 on the file of additional judicial first class magistrate such and such are said to be open-ended warrants without any direction for return of warrants. So there is no specific direction in the order saying return of warrants. If unexecuted on or before a specified date, Therefore, we have no hesitation to hold that warrants will never become dead or lapse, and they will remain in force till they are executed or returned by the police officers or the authority to whom they are entrusted, or they are cancelled, withdrawn by the competent court. None of these have happened here. In the instant case on hand, the warrant of arrest were neither cancelled nor withdrawn by a competent court, nor returned unexecuted by the police officers. Thus, there has to be a finding of the police officer or the authority to whom the warrants were entrusted. In those circumstances, the warrants are deemed to be alive and can be executed at any time till they are cancelled or withdrawn, or till they are returned on execution or returned unexecuted. Accordingly, the point is held against the petitioner in favor of the respondents. So this is the division bench, my lord, which has held in the same court. And now, my lord, kindly sees, my lord, paragraph 9. From the above findings, it is clear that the warrants will never become dead or lapse, and they will remain in force till they are returned by the police officers or the authority to whom they are entrusted, or they are cancelled, withdrawn by the competent court. The court has also held that if any date is fixed for execution of warrants, but not for return of the warrants, very important, my lord, if not executed, there is no bar in returning the warrant even after lapse of some time. Thus, categorize warrants is open-ended as open-ended warrants which do not contain any direction for return of the warrants if unexecuted on or before a specified date, or a close-ended warrant which specifies a date on which the warrant is required to be returned after execution or otherwise. Now, here is the case where the court is extending it. And therefore, my lord, it is not a case that the court has, my lord, cancelled the warrant, or my lord has given a date, my lord, within which the police officer has even filed a report saying that it has been returned unexecuted. Now, my lord, a similar case came up before this honorable court, my lord, and see,
In the same judgment, please read para 15 and 16.
Yes, my lord, kindly takes 15. My lord, kindly takes also para 10 before that, my lord, kindly sees, my lord.
Yes.
In the instant case, the principal assistant sessions judge's court, Illuru, passed an order dated 15th of July 2015, appointing Mr. Such and Such as an advocate commissioner for taking physical possession of the petition scheduled property, make inventory of the articles under a panchnama, and hand over possession of the scheduled property to the petitioner bank therein. The advocate commissioner was directed to execute the warrant within 1 month from the date of receipt of the warrant, failing which the authority to execute the warrant stands cancelled. So that, my lord, is worded in the order itself. Where is that in this particular order before, my lord? And kindly sees, the commissioner was further directed to file his report forthwith after execution of the warrant. And apropos that, lordship is correct. My lord, paragraph 15, my lord, has been passed by the court. This is not a case, my lord, with similar facts. Here, my lord, the warrant was executed to be within 1 month, failing which, my lord, it would stand cancelled. And that's the language of the division bench, which I read out from paragraph 8, my lord. That if that is so, then, my lord, it would really stand cancelled or withdrawn. Otherwise not, because the statute does not permit that. It would be then contrary to the statute. In the facts of this case, my lord, before the Andhra Pradesh High Court, my lord, therefore, my lord, this order was passed, which is at paragraph 15. We are now in the agreement with the procedure followed by the court. As stated earlier, there has been an application seeking extension of time, giving reasons as to why it could not be executed within the time fixed by the court. Of course, this procedure, in our view, will not apply to cases where no time limit is not fixed for execution of the warrant. So the distinction is also carved out in paragraph 15. In our case, no time limit, my lord, as in paragraph 10 has been carved out. And contrary to that, the, my lord, time to file the report has also been extended, which my learned friend has not enclosed before, my lord. He should show that, my lord, the court has said this is the cutout date. I'm not going to extend any further. So the extension has been given by the court, and not a fixed period warrant for execution like in this case, as paragraph 10 has been spelled out, my lord. Now, where is the order that he has enclosed? After, my lord, let us, my lord, rely on his document itself. After this, my lord, recording of the court, my lord, of 25th of April, I think, my lord, what was the page 59, na? No marking. Or kindly sees, my lord, that date, the last, my lord, recording, 19th of April 2025. Where is the order after that? Extension. Whereas I have got instructions, the court has extended it further. So therefore, my lord, how is the writ petition maintainable before my lord?
Have you put all the orders, sir?
Yeah,
Your lordship, on which date we have affirmed the writ petition? On 17th, we have affirmed the writ petition, and your lordship kindly sees.
So this, see, he has a point in his submission that if the order is being extended, then the compliance report, the time is being extended by the court.
I'm answering you. If your lordship kindly sees, after the last order on 4th of April 2024, Malad, we have obtained a certified copy. We affirmed the writ petition on 17th. So there is no scope for us to obtain an order after that.
You get the certified copy.
And Malad,
file an additional document.
So for the extension of is concerned, Malad, in any manner, Malad, this page 52 cannot be issued by one. Now the commissioner may or may not, that is the question to be decided. Malad, so for the page 52 is concerned, Malad, in any event, with the strength of this order as a presented.
Sir, as far as this is concerned, then you should go to DRT.
Yes. So for the
is concerned, you go to DRT.
So for the notice is concerned,
you go to DRT.
The DRT don't have any jurisdiction. So for the notice,
the notice has been issued in terms of section 14 itself.
And answering to his query of reading page paragraphs 8, if your lordship kindly sees.
I don't need to read that. If the compliance report is being called by,
it has been dealt with in paragraph 12 and 13. If your lordship kindly sees once,
sir, there is no word as warrant has to be returned. All right. The judgment which you are relying upon, there's a specific direction that the warrant has to be returned.
He is referring to is in respect of a 200 proceeding. The nature of the warrant is completely different.
Sir, as far as the compliance report is concerned, if the court is periodically extending the compliance report, then it means that the time is been given by the court for them to complete the act. Then there is no cutoff date which has been put.
That answer has been given in paragraph 12. The cutoff date is not required. The court cannot do it mechanically. If your lordship kindly takes up paragraph 12, the proposition he has presented from paragraph 8.
Then in that case, sir, you put all the orders on record. We will examine if the court is mechanically doing it or is applying his mind.
Malad, I have presented all the order before your lordship up to the date when Malad, I have filed this writ petition.
Today, when it is listed for hearing, when it is listed for hearing, more orders have been passed. You put that also on record.
Only one order, Malad. If they are realizing, Malad, they must having that order, Malad.
I can apply for a certified copy. I have nothing to hide.
Certified copy.
I can file.
And so far, Malad, certified copy of the other orders are concerned. Malad, up to date orders are with your lordship and with the certified copy.
Yes.
As it is following from my other side, Malad.
Malad, not from that only I am saying that it is still 19.4.
And as far as this letter is concerned, you should.
It is a wrong exercise of power.
You should go before the DRT, not before me. This is done under section 14. Anything which is arising out of that surfacey proceeding, you go before the DRT. DRT already had given you a finding that the lawyer was not involved. The second DRT finding was contrary to the DRT finding. If you are challenging that, that's a different thing altogether, but you are not challenging that. You are challenging this notice. This notice you should challenge before DRT.
I have challenged the notice as at page 52. So for the nature of this notice is concerned, on the other day I have also submitted. This is absolutely violation of natural justice and palpably wrong in the eye of law. In any event, the commissioner, advocate commissioner being the same person who has filed the application on behalf of the bank before the tribunal cannot issue this notice even after the expiry of the date on which the magistrate has fixed on which date.
That is the dispute, sir, that the magistrate has not fixed a date. The magistrate is extending the date time and again because the word which is being used is compliance report.
My lord, your lordship kindly
And
takes
the
up.
compliance report date is been extended time and again.
My lord, my lord, your lordship kindly says it has not been extended. Kindly, my lord, once more, my lord. De facto complainant date is fixed for report. No report received. Case is adjourned.
That's the same report which is dated, stated above.
No report is
No
given.
report is required.
Look at the date which has been extended.
My lord, then
Look
my
at the order which is there, sir. The applicant is to bear the cost for providing force by the police force. Let the original document be returned to 23/3/2024
That
for
is
compliance
exactly
report.
what is there in paragraph 12. Your lordship kindly sees paragraph 12 once. Once, my lord. His paragraph 8 has been answered to.
Yes.
A reading of the above order would show that pursuant to the order dated order passed in such and such on the file of the
Where are you reading? Which para 8?
paragraph 12. My lord, para 8. He has, my lord,
Para
he, my
12,
lord,
sir.
referred to para 8.
Yes. A
Para
reading
8
of the above order
reflects
would show.
in
Yes.
respect of a warrant which has been passed in a 200 proceeding, in respect of a person, particular person. So for the, my lord, proposition of this order is concerned, that is reflecting in para 12 and para 13. Your lordship kindly sees. Let me read it.
Yes.
A reading of the above order would show that pursuant to the order passed in such and such on the file of DRT such and such, warrant was
Reintrusted.
to same commissioner for its execution. The order is silent as to what happened from the date of the order passed on 15/7/2015 till a fresh warrant was reintrusted
The fresh warrant পেয়েছে।
on 4/3/2022. In fact, the order dated 15/7/2015 clearly indicates that warrant has to be
1 month.
executed within 1 month from the date of receipt of the warrant. In this case also, my lord, the date has been fixed within which date the order
Where
has
is
to be
it, sir? You show me where is it? Where is it?
কোথাও নেই।
Where is it?
Your lordship, kindly, may I place it, my lord? Clearly indicates the warrant has to be executed within 1 month from the date of receipt of warrant, failing which the authority.
Where are you reading, sir? Where? Where are you reading?
Well, at paragraph 12.
Oh, forget
Your
that.
order.
You show from your order. Where is such finding? Where is the word warrant? That it has to be returned.
Warrant, the word warrant is not there. My lord, your
Then,
lordship,
sir, what is there?
Then the nature of the direction is a warrant, my lord. If your lordship kindly sees, the applicant is to bear the cost of providing force to the police as per law. Let the original document be written to 22/3/2024 for commissioner's report.
That's what I'm saying, which is getting extended.
Like if it is it has got extended, my lord, then in that
Your own report says it is getting extended. Read further those orders. It is getting extended.
Your lordship kindly sees, my lord, paragraph 13 was, my lord.
Para?
Paragraph 13 of the order, the judgment. If the warrant is not executed, return within time.
No, that's what I'm saying. It is getting extended. Why are you reading this judgment? I've understood your judgment. I've understood your contention.
My lord.
It is not evolving from your pleadings on record, sir.
My lord,
Your order on which you are relying is not helping you with the judgment.
my lord, so far the page.
It is getting extended. There is no time limit fixed for the warrant to be executed that I can rely on the judgment. You read yourself. The compliance report has to be filed first on 22nd of March 2024. Further gets extended on 22nd of March. The matter is listed, gets extended to 13/6. Then on 13/6, it gets extended to 4/9. On 4/9, it gets extended to 19/7.
Malad, in my submission, it has not got extended. Malad, it has, your lordship kindly says there should have been a separate application for such extension. Malad, that is the proposition. Your lordship kindly allow me to present paragraphs 12 and 13.
But I have read that, sir.
Malad, there is no application. There was no application. Malad, the magistrate was to malad, give a date in the proceeding. Malad,
Why
magistrate,
didn't you move an application before the magistrate? Asking him to clarify.
malad, give me that liberty. Malad, I will.
You go there, you don't need liberty
Malad,
for
give,
that.
give me that
Liberty
liberty.
is
Malad, I will.
required.
Liberty, sir.
Malad, this
You don't
page
need
52
liberty.
cannot be issued by the same commission. Your lordship
Not
kindly
his
appreciate it.
feelings.
This is an exercise which should have been interfered by the malad, report. Your lordship.
As far as that is concerned,
Malad.
you go back to the DRT, show it to the DRT that what is
Malad, I have exhausted the appellate forum. There is no scope for me. And this is going on, Malad, and it is before your lordship, Malad. Your lordship kindly interferes, Malad. This is palpably wrong, Malad. This is an exercise.
If my lord, as I said, if the commissioner is an issue, lordship appoint somebody. I have no issues. I have no issues with that.
If from that even the
How does the order goes? How does the order, my lord, order remains? If there is a my lord, issue with regard to the personnel, as I said at the first instance, lordship will appoint anybody. It does not matter, my lord, who is the personnel. Lordship will appoint any personnel. We have no issues with regard to that. That lordship can always do.
If that is the Malad, if
Malad,
that is
it
the
has been
conduct,
appointed.
how the
No, it's not a
exercise,
conduct.
Malad?
It's an order appointed by the Malad magistrate. Lordship wants Malad, somebody Malad to be appointed in his place. We are always agreeable.
I don't want to give any finding right now. You go before the magistrate. Let him first.
Yes,
sort it
we
out.
have no issues with regard to that, Malad.
This is the only thing which.
And Malad,
disturbs this court.
kindly Malad sees also 17th April 2025, he affirms the writ petition when he knows from his own order as paid 59 that the extension is till 19/4/2025. So you should have waited at least till 19/4/2025.
In the meantime, I was put in a notice that on
But the
19th,
extension is already there.
And I will wait.
Till 19th, as it is, the order is there.
And the same person.
You are protected till 19th. What is the extension?
Malad, the extension was till 19/4/2025.
What happened after that?
Malad, it has been extended. I can file the certified copy even.
Till when?
I can, my lord, apply and file it before my lord. Court orders, my lord. I have no issues.
Lordship kindly sees
you
there
go
was
before
no
the
extension, only the dates were there.
This perhaps
And
he
for
should check the
extension, Malad,
records.
the proposition
Don't
is,
say-
Malad, he
Sir,
will have to
that
make
is a wrong submission. That is absolutely a wrong submission.
that is my understanding.
That is absolutely incorrect understanding till the time you don't get a clarification from the court.
Malad, so far, Malad, this judgment
There
is
is
concerned.
no warrant.
They should have come with an application. They should have come
If
with
you
an
want me to dismiss it, I can dismiss it on that ground. That will prejudice you. That will absolutely prejudice you. I have no problem in saying that the CGM has not given any returnable date. Compliance date was fixed, which has been extended periodically. In view of that, this is not waiting. I'll dismiss it. I have no problem in stating so.
And so far, the Malad Advocate Commissioner's point is concerned, Malad, your lordship kindly, Malad.
Advocate Commissioner, you should have challenged the DRAT order, which you have not.
We have challenged before the DRT. Your lordship kindly sees the findings of the DRT.
DRAT order, you have not challenged here.
That
You
is
challenge DRAT order. Tomorrow, I'll give you a finding.
Malad, the liberty may
But
be.
today, my lord, I'm agreeable to it. Even though he is not challenged, I'm agreeable, my lord. Lordship appoints anybody.
I will not. That is not the subject matter here.
Malad, only one thing, Malad, your lordship kindly keeps the scope open because we have already taken step to challenge that order by way of a filing civil revision. Well, that is the.
Well, that he has already, my lord, that no scope, my lord, liberty is to be given.
Already there for you.
Yes, yes.
Learned counsel for the petitioner seeks to withdraw the present writ petition to avail his remedies available in law. Full stop. In accordance. Present writ petition is dismissed as withdrawn. You challenge the DRAT order. That finding is wrong.
Grateful, my lord. Huh? Deeply obliged.
Malad, only one thing, Malad, your lordship kindly, this notice will suffer me, Malad. This notice will suffer. Malad, then
I can't set aside the notice, sir.
Grateful.
Next.
Agenda 2.
Item number 2, my lord.
No.
बोले
Right,
दीजिए, बोले दीजिए. My lord, before your lordship starts, my lord.
Not today, Monday.
Very well.
हाँ,
The number is
हाँ.
Item number 3,
I'm for the petitioner, Your Lordship. Petitioner does not wish to proceed with the matter, Your Lordship.
Learned counsel for the petitioner does not wish to press the present writ petition. The same is dismissed as withdrawn. Instruction received from the client is taken on record. That's the instruction from the client, right?
Yes, Your Lordship, my
The instruction from the client not to pursue the present writ petition is taken on record. Affidavit of service is taken on record.
Security क्यों है बस?
Dismiss it.
Number 4,
I am for the Rajput of municipality.
Lordship, I am for the petitioner.
Yes.
I am for the petitioner.
Yes.
Lordship, my prayer is that we want to withdraw the case with a leave to file a new petition.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is
Grateful.
dismissed as withdrawn.
Grateful, Lordship.
item number 5,
My lord, I am for the petitioner. I am led by Abhimanyu Banerjee. My lord, as per the last order, there was a direction to serve a copy of an order to respondent number 4. That is the chairman of Vildanda municipality. We have served a copy, but till now we have not received an affidavit. My lord, kindly fix a date for hearing on Monday.
ये किस देखना किसी का नाम है बिलदंगा म्यूनिसिपैलिटी का उसमें है लिस्ट में नाम है
Respondent number 4, my lord, the chairman, Vildanda municipality.
You have served them.
Yes, my lord, we have served that. And affidavit of service is not complete, but service letter has been complete. It's complete.
File the affidavit of service. नहीं है This is let a copy of this order be sent over to respondent number 4. No affidavit revival. Report is not clear. Who has filed this report? I have asked, direction has been given to send a copy to respondent number 4. Why that direction has not been followed? किसको बुलाना Point number 4. Before the next date of hearing. We'll keep it next week.
Yes, ma'am.
Wednesday.
Next week.
Next week.
বুধবার কত 30 তো
Next week. বুধবার না?
30
Item number 6.
Grateful lordship.
Friday रख दो इसको, वो हो नहीं पाएगा, 4th कर दो. Keep it on 4th.
4th, ma'am.
4th of,
Grateful lordship.
4th of May. What is this? No, 5th of May करो इसको.
5th of May.
5th of May.
Grateful lordship.
Item number 6, Your Lordship, I appear on behalf of the petitioner. Lordship, this was the matter Your Lordship would recall. They'd made certain unauthorized construction in front of my plot, which was inhibiting my access to my plot, the ingress and egress to my residential house. Your Lordship, I directed the Howrah Municipal Corporation to file a report. We've not received a copy.
Yes,
It's for them.
Mr. Banerjee.
I have got instructions, I will file a report. So far as the rear is concerned at page 12.
Yes.
Read on the nature of mandamus commanding the respondent, especially the respondent number 2, so and so, to restrain the private respondent from doing any illegal constructions at plot so and so, and further direct the municipal authorities concerned to demolish the illegal construction made by the private respondent during the pendency of the representations made by the petitioner. And so far as in answer to this prayer, my lord, we have taken steps for we have given the police that unauthorized construction is going on above the ground floor, because it is a ground floor building has been constructed. RCC columns are unauthorized.
Work stop notice you have issued.
My lord, we have issued a letter to the officer in charge that they are carrying on constructions. And my lord, next is if your lordship's business, I have already taken instructions, but we will file a report regarding this. And construction is stopped as I have found, as I have been instructed. So we have taken steps. Now hearing is required to be given as per 177. After the hearing, so far as demolition is concerned, will be done after the hearing.
No, for unauthorized illegal construction, ongoing construction, you can demolish it.
My lord, no, we have to make a hearing.
For ongoing construction.
Ongoing construction, we have to give a stop work notice immediately and intimate the police. We have intimated the police. Now we will call them for a hearing. Thereafter, we will give them self-demolition notice, and thereafter
do it in a time-bound manner.
Time-bound is not given.
Yes.
177, madam.
Of KMC Act.
Of
HMC.
Howrah Municipal.
Howrah Municipal.
HMC.
I will use
Time bound then. Yeah, time bound. Time bound is only given in case of self demolition. That is there also. I am showing that provision.
Yes.
Firstly, my lord, 177(1). That is at page 191.
Yes.
No, no, there একটা আমারই বই, আমি বই। Has been commenced. That has been started. And
or is being carried on.
Or is being carried on. So it is carried on. It was carried on as reported. And we also found that the construction was going on above the ground floor with RCC columns. Immediately, we have made inspection. We have given a stop work notice. Now we will give them a hearing. Hearing is required to be given. And thereafter, we will pass the self-demolition notice. In case of self-demolition notice, there is a time of 5 to 15 days. That we will give. Lordship was asking me that how much time I can give. 5 to 15 days, my lord.
Now the private respondent is alleging that civil suit is pending. So far as civil suit is concerned, my lord, 177(5) says that no court shall entertain any suit.
That section is irrelevant.
I'm placing, my lord, nothing else.
You also know it.
I also know, my lord.
That section is in all.
All. But High Court has enormous power. High Court can always entertain, and High Court is entertaining also, Honorable High Court. And my lord, now we will give a hearing. If your lordship give me some time, hearing will be called very soon. Thereafter, we will see for demolition and everything. So far as the allegation in the writ petition has been taken care of.
Your Lordship, may I just point out one practical incongruity that may hinder me, Your Lordship, and this I submit upon instructions. Your Lordship takes up page 39 of my writ petition. The injunction order that I am suffering, that has been annexed. However, Your Lordship, if Your Lordship is with me, I'll just place it once. The defendant and or any person related with him in any manner is hereby restrained from doing any activity which would create disturbance, annoyance in the peaceful possession of the suit property. So this is limited to the peaceful possession. Your Lordship, this order they will show to the local police station and they're going to circumvent whatever activity has been directed. So just if Your Lordship could just clarify in Your Lordship's order, I need not embellish Your Lordship's wisdom on that. Lordship is...
Civil dispute, I should not even comment about it.
I bow down to Your Lordship on that.
Nothing to do with this.
But Your Lordship, the admitted case that is...
admitted case, they are taking action. They are admitting it. There's unauthorized construction. They have issued the work stop notice.
Yes, Your Lordship.
And in the civil court also, Howrah Corporation is not a party, I suppose.
Well, civil dispute also, how will I...
No, we are not a party there, so far as I think. Now, my learned friend can say about that. I don't know. I think I am not a party.
Learned counsel for the respondent, Howrah Municipal Corporation, Mr. Sandeepan Banerjee, appears and states that a work stop notice, which is the first one, Mr. Ganguly? 9, sir. A work stop notice has been given on 9/7/2024, and copy of the same has been marked to the officer in charge, Jagotra. What is this?
Jogacha, my lord.
Jogacha.
Jogacha Police Station, Howrah.
Full stop. Learned counsel for the respondent corporation states that they will ensure that no unauthorized construction is carried out and they will proceed in accordance with the law to demolish the said unauthorized construction after affording an opportunity of hearing to the person concerned in terms of section 177 and thereby pass an order of demolition if the corporation finds that the person concerned is raising illegal and unauthorized construction in violation of the building plan and without grant of any sanction plan. Full stop. How much time?
4 weeks.
Mr. Ganguly says.
Sandeepan Banerjee. And I'm unfortunate.
The reason is Sandeepan Ganguly was appearing every day.
I recognize. For criminal.
Mr. Sandeepan Banerjee states that they will make all endeavors to complete the due process as enumerated under the law within a period of 8 weeks.
Well,
full stop.
Sufficient.
Within a period of 8 weeks.
Sufficient time for us.
Learned counsel for the petitioner states that in view of said statement, he does not wish to press the present writ petition at this stage since the demolition, the stop work notice has already been issued and the corporation will act in accordance with law if any illegal unauthorized construction is found on the said property, full stop. In view of the above statement, the present writ petition is disposed of in terms of the
Yes.
directions.
May I
passed
just
by
pray
this
for
court.
one indulgence, Your Lordship? I apologize for troubling Your Lordship with this. The submission that I'm not pressing this writ petition, Your Lordship, if that can be.
And what do you want to do? You want to get reports filed?
Yes, Your Lordship, if the reports.
All right. Strike down the order. Mr. Ganguly states that a work stop notice has been issued, full stop. He
Mr.
takes, Mr. Banerjee states that a work stop notice has been issued on 19/7/2024, 9/7/2024, full stop. He seeks further time of 6 weeks to file his report, full stop. Exception to the same, if any, after 2 weeks, 8 weeks, 10 weeks.
No, no time, we need to child. 6 weeks, 2 weeks, 10 weeks. 6 weeks about the report file.
By that time, 2 more floors will come up.
They are not wanting to dispose of. What order would have been?
I mean, I fail to understand.
Instruction, Your Lordship, however, if Your Lordship's wisdom prevails, Your Lordship, I have nothing to.
Dispose করলেই তো ভালো হয়, স্যার তো ঠিকই order দিয়েছে।
Then let it, because Your Lordship's wisdom will prevail.
His purpose has been served.
Purpose has been served, Your Lordship. In fact, Your Lordship has been very benevolent to.
Today you have an order with a time frame.
Yes, Your Lordship, that's what I was.
And today you will go back from here after 10 months.
Yes,
What do you want?
Lordship, then Your Lordship, if Your Lordship's
No
wisdom
purpose will be
prevails,
served.
let Your Lordship's previous order.
I am not doing, I am not saying it.
Let Your Lordship's
I am
previous
not
order.
saying anything, but.
Let Your Lordship's previous order.
Just want to say this skill, since your lordship is kind enough to record in your lordship's order that.
But I have given the entire.
That he wanted to avoid, like, why did I pull it?
Yes, Your Lordship, I'm a beneficiary of his guidance, but if Your Lordship's wisdom so prevails, I will just request.
Yeah,
Your Lordship.
I have given the entire direction to the extent.
Yes, Your Lordship has been kind enough to set the time, Your Lordship.
What more?
এর থেকে ভালো আর কি direction?
Let the previous order remain, Your Lordship. I pray for that.
So, my lord, disposed of.
Grateful, Your Lordship.
Directions passed by this court.
Content করতে পারবে তো, dispose of it.
Lordship, Lordship, I most humbly apologize, but with your permission, I would once again like to mention 84. Lordship,
How can you mention in between, sir?
I'm extremely sorry, Lordship.
Sorry.
I most apologize, most humbly.
Not allowed. No mentioning in between.
My Lordship, AD for matter 4, item number 4, Lordship.
You have already, that matter is
No,
not-
Lordship, I most humbly apologize, Lordship. I just want to mention one thing that in the order, I had also asked for a leave to file a fresh writ petition, Your Lordship, with the withdrawal.
Already have liberty in law. I can't give you any liberty which is not available. Just take down in item 4. Petitioner is at liberty to file appropriate proceedings in accordance with law.
Grateful, Lordship, grateful.
Yes.
Item number 7.
Would appear for respondent number 6 and 7.
Respondent number 6 and 7.
Even 7. Respondent 5 and 6.
Action করতে হবে।
Yes. Yes, sir.
Who is the
They appear
petitioner?
for the respondent number 6.
Who's the petitioner, sir?
I'm for the petitioner.
Yes.
Kindly seize your lordship's previous order, I'm appearing for the respondent number 7. It's my lord. We have taken a no objection from the.
My lord, I'm in a predicament, my lord. I'm in a predicament, my lord. In the affidavit in opposition, it is mentioned that I am filing this on behalf of respondent number 6 and 7.
When the affidavit
Clearly
was
speaking,
affirmed, my lord, the respondent number 7 had authorized.
was with us. Now he has left us. So, my lord, the affidavit may kindly be allowed to be corrected.
We have no.
Now correction करो। तो सबके बोले correction करो।
What do you want, sir?
We would like to file the affidavit in opposition, my lord,
You are appearing for
for respondent number 6.
respondent number 6.
But if your lordship looks at the
The partners of the respondent number 5, I am one of the partners of the respondent number 5.
I'm the
But
builder.
inherently, my lord, when the affidavit was affirmed,
My
the
lord,
respondent number.
we had instructions to file it in respondent number 6 and 7 as well. So it is mentioned, you know, affidavit in respondent number 6 and 7. Subsequently, respondent number 7 has obtained a change. So we may be allowed, my lord, to make this correction in the affidavit of respondent number 6.
And I think that is to be required to be corrected. I think.
File a fresh affidavit.
Yes, that is required, man.
No correction.
That cannot be.
Learned counsel for
when-
the respondent number 5 and 6.
Only 6.
It's learned counsel respondent number 6. 2 weeks time to file his affidavit. Yes.
Only one.
1 week time to file his affidavit. In reply about his affidavit in opposition. Is it affidavit in opposition or what are you filing?
Affidavit in opposition, my lord,
Affidavit in opposition.
pursuant to your lordship's direction.
Affidavit in opposition.
May be allowed to strike out the name of 7.
File a fresh, sir.
Fresh affidavit, as we lordship.
Within a period of 1 week, full stop.
Fresh affidavit.
Yes. What do you want?
I'm seeking to appear for the respondent number 7.
Learned counsel the respondent number 7 seeks similar prayer. 1 week time is granted to the respondent number 7 to file his affidavit in opposition. Exception to the same, if any, within 1 week thereafter.
No, now I am.
You are the main customer. They
So
are all.
I have to file a report. Report is there, my lord, with me. Yeah, if your lordship wants me to file a report in the form of affidavit, it will be better. I will.
Learned counsel for the respondent corporation also seeks similar prayer.
Report is ready with me, my lord.
He shall file his report in the form of affidavit within a period of 1 week. Exception, if any,
Yes, advance copy will be served.
within 1 week thereafter, list after 2 weeks.
My lord.
Not only the copy of the report, if it can be circulated.
Copy of the report shall be handed over to the parties.
Without affidavit, I will hand over.
No.
Without affidavit.
After the affidavit.
After the affidavit.
Along with the affidavit, my lord, so that he can deal with
Advance copy.
advance copy.
My lord.
Oh. Mr. Bhattacharya, you filed the Calcutta in the department.
Very good. Well, I
You have
was
time to.
only humbly requesting, since
Yes.
your lordship is kind enough to direct me to use an affidavit. If the report may be informally circulated so that we can deal with it.
No.
Whatever we, or we take an action. As your lordship.
That will be.
As your lordship.
I cannot because my lord.
I'm not saying that, Mr. Bhattacharya.
I know, my lord, but I am answering him.
I will not put you in any embarrassment.
No. I have deepest respect to your lordship.
But I believe your lordship has given us 1 week's time to file the
Yes,
affidavit.
sir. 1 week, sir.
1 week's time.
1
my lord.
week time to you also to respond number 7, who was your friend earlier, who has turned a foe.
Yes.
And the
Provided
friend
we will
turned enemy.
No.
my lord, provided
We
we
are
get
sailing in the same boat apart from certain.
we get the
regulations.
municipalities, my lord,
1
affidavit and the report in the meantime.
1 week.
The issue here is not whether there is a plan or not. We have.
But
the
I'm
plan.
instructed to
That
pray
is the
for
only-
2 weeks' time, my lord. 2 weeks for filing the affidavit.
Then 1 week, 2 week for everyone. Huh?
2 weeks for filing the
Municipality also 2 weeks.
2 weeks.
And 3 weeks.
Wait.
After 3 weeks.
Okay.
কত তারিখে আসছে? কত তারিখে আসছে? দাদা, কত তারিখে আসছে?
Item number 8.
I appear on behalf of the petitioner, Your Lordship. This is pertaining to the list of Justice Sinha only for extension of interim order. So the interim order is expiring on 30th of April 2025. Your Lordship, kindly.
हो जाएगा ना 2 weeks
4 weeks. 23rd May. 23rd May.
23rd May.
23rd May.
Which was the first order which was passed?
Lordship, the first order that was passed on is on 19th of October 2023, staying the operation of the impugned order dated October 10, 2023. Lordship, that has been extended from time to time.
I know. I'm just saying the first order, sir.
Lordship, 19th October 2023.
Whose order is that?
Lordship, 19th October 2023, passed by Justice Sabyasachi Bhattacharya.
Still going on. What is the
Yes,
matter?
Lordship. Lordship, this is a matter where there have been simultaneous proceedings, one by the
Where is the other side?
Lordship, Miss.
Are you the answering respondent? Who's the answering respondent, sir?
Lordship,
Have you
the
served
state.
them?
Yes, Your Lordship, we have served them. Lordship, we have served them by email, both that it was mentioned yesterday and that it is there today.
When is the order expiring? 30th?
30th of April,
Sir,
Lordship.
you serve them again. We'll have it on Monday.
Very well, Lordship.
Serve them again. Affidavit of service should be filed.
Very well, Lordship.
I will not extend it otherwise. We'll have it on Monday.
Very well, Lordship. Great.
Monday, just keep the matter on Monday. Not today, Monday. Monday would be what?
So 28th, I believe.
28th. Keep it on 29th. Keep it on Tuesday.
Very well.
29th. You serve them.
Grateful.
Item number 9. For the respondent number 2.
My lordship, I appear for the petitioner. I am led by Miss Khushbu Chaudhary in this matter. She is on legs before another court. I am praying for a short Passover.
Won't be possible today.
My lordship then kindly keeps it on Monday. This is for extension of interim order, my lordship.
Are you opposing?
And I will be opposing only on the ground matter because probably the writ petition is not even maintainable. This is an order passed.
This is not my roster, right?
That I understand, but
Justice Sinha. So all these contention, everything you can raise before that court.
and I
for
bow down to your
extension.
lordship. The only thing is that this is a dispute in regard to giving water connections. The developer has
Yes,
developed
your
a property, not given water connections to half the flats.
That's all right. When is the extension getting over?
The 30th of April, my lordship.
I think she's here. She's here. Yes, Miss Chaudhary. Miss
Lordship.
Khushbu Chaudhary. Yes.
Lordship.
Yes, tell me.
Your lordship. Your lordship, the interim order is expiring on this 30th, your lordship. Be kind enough to extend the interim order, your lordship.
They are opposing the interim order extension.
Your lordship, affidavits has been exchanged between the parties, your lordship.
I'm sorry?
Affidavits has been exchanged between the parties, your lordship.
So it's listed for arguments.
Lordship.
If affidavits are exchanged, then what is
No, your
the-
lordship. I'm just humbly praying, your lordship, kindly extend the interim order, and your lordship kindly keeps it on Monday. We'll do the hearing on Monday, your lordship.
Go before the regular bench.
But it may be extended for a short period of time. Otherwise, this hearing is this is a 2023 matter. There is an
Order that
appellate
is
forum.
subsisting in the matter is extended till 15th of May 2025 or until further order, whichever is earlier. Liberty is granted to the parties to mention the matter for hearing before the regular bench. Before any bench having determination.
Deeply.
Deeply obliged.
Whatever. Alright, sir. Number 5. 5. Item number 10.
So I'm for the petition. Kindly takes up the application seeking extension. This is scan 1.
Justice Sinha's board.
No,
My-
yes, Lordship Systems. Kindly sees the order dated 12th September 2024. Prima facie, I am satisfied that the case of the petitioner should have been considered in the light of the order passed by such and such by a division bench. The petitioner of this case appears to be similarly circumstanced with the petitioners. In that case, the relevant part of the order dated May 9, 2024, passed by the division bench is quoted. The order is quoted. Thereafter, my lord, it does not appear that the impugned order of demolition dated June 24, 2023 has been passed in light of the direction of the division bench as quoted above. In view of the matter, there shall be a stay of operation of the rescind order dated such and such for a period of 7 years. The petitioner shall add such and such copy to be served. Thereafter, my lord, intra-court appeal was preferred. It was extended. Kindly see page 11 of the application. It was extended, and thereafter the intra-court appeal was preferred against this, my lord, interim order. That order, intra-court appeal, was, my lord, dismissed. Kindly comes to page 11 of my application. I have annexed the order dated 19th November 2024.
Where's your application?
This application is scan 1. My lord, lordship has been
Okay.
given the application. My lord.
Can one can?
Oh, can 1 is not there. Would your lordship take my copy? My lord? Copy that.
Can one? Can one is not here.
Lord, kindly takes my copy, my lord. Kindly sees the order of the division bench. Kindly takes my copy. Page 11, my lord.
But why can one is not here?
It was mentioned it's supposed to come from the department. I think it has been filed.
When did you file it?
Filed in this court.
No, court 15.
Oh, it has been filed in courtroom number 15. So the, my lord, I think the can is lying in that court.
It's your duty to get the can listed here.
It has
Yes.
to be repositioned from that court. Kindly, the list it is appearing. But kindly comes to page 11, my lord.
Yes.
This is, my lord, the order passed by the division bench. Appeal is directed against an interim order passed by the landed single judge in such and such. By the impugned order, landed single judge granted stay of an order of demolition. Landed single judge noted that the writ petition was similarly circumstanced as that of the parties in a pending appeal. Landed single judge also referred to the order dated such and such passed by the division bench. We invited the landed advocate for the appellant to draw our attention to any fact by which it can be said that the landed single judge exercised discretion irregularly in granting stay of the order of demolition. Learned advocate affirmed the appellant is unable to do so. Corporation and the private respondent are represented since the appeal is directed against the interim order, and since we are not in a position to arrive at a finding that discretion exercised by the learned single judge was irregular, we are not mandated to interfere. Along with the concerned appeal are disposed of without any cost. But I'll be praying, my lord. In the meantime, the interim order after this order has been passed, my lord. This order is of my lord, November. Interim order expired in the month of December. And my lord, we have filed this application subsequently. My lord. I'll be praying for extension of this interim order and my lord, hearing of the writ petition as it comments to your lordships, my lord. And I'll be also praying if they want, my lord, they can file an affidavit in opposition so that, my lord, the matter can be thrashed out before the lordship.
Yes.
Lord, unauthorized construction without any plan.
Where's the report?
Lord, there was no direction. Lord, will kindly take page 36 of the writ petition. The reason
That is on merits.
Last paragraph, my lord. The petitioner is named, my lord, Kollani Makhal. Last paragraph, third line. During hearing, Kollani Makhal appeared in person and claimed to be the occupier of the said plot. She submitted that the subject plot is RA plot, guide number 641 at Shantinagar under Government of West Bengal, and she has been in possession of the subject plot since 41 years. The occupier further submitted that she has neither possessed documents relating to the land nor got building plan sanctioned by appropriate authority prior to erection of a G plus 3.5 story construction. So there is an admission, no plan. Now, Miller, my learned friend is seeking the benefits of, Miller, the order which is appearing at page 38, passed by the Honorable Division Bench, Miller, presided over by the Honorable Chief Justice, Miller. That is in WPA 1410 of 2024 at page 38.
Yes.
There, Miller, there was a, Miller, executed deed of lease. Now, in this case, there is no lease deed executed. So, Miller, in any event, the circumstances are different, Miller. They cannot seek the benefit of this order. Page 39
in any case,
is,
my lord, that is on merits, my lord. Lordship is not
Page
taking the matter
39
on merits. These points were argued.
This was in a different matter. This direction was passed. Huh?
Milord, it was a different matter. There, Milord, the petitioners claimed that they could not, Milord, produce.
File your affidavit. File your affidavit, we'll finish it off.
Yes.
All that.
Well, may I come, Milord, one submission, Milord, 295A. There is a.
Then you put that in an affidavit. Without affidavit, how do I decide the matter? Just take down. The interim order, which was granted on interim order granted on September 12, 2024, was subsequently extended on 11/11/2024 for a period of 6 weeks. 6 weeks, right?
Yes.
So it is expiring when?
It has expired. Expired in the meantime.
It has already expired.
Yes.
Learned counsel for the petitioner has filed. Where is your can? When did you file the can?
Month of February.
Why should it be listed today? What is the urgency then?
Well, for extension of interim order, it has been mentioned.
Where is the can?
Can is there, but it is
The can here. Why should I pass an order when the can is not on record?
that is for the
Learned counsel
department
petitioner shall ensure that the can application.
But it is not for us, it is for the department to bring the can.
The can is not on record. Let the can application be placed on record. Let this matter be listed. When do you want? After 1 week. After
1 day, because there is an urgency.
What is the urgency?
Urgency is that the urgency was pleaded here also.
You are waiting since when? When did it get expired?
But it's expired in the month of December.
December.
Yes.
So from December till April, no injury.
It was mentioned twice, before
after 2 weeks.
For the previous
in the meantime, the corporation is directed to file their affidavit in opposition. Exception, if any, within 1 week thereafter, list after 4 weeks.
My lord, I'll be at liberty to seek for because there is an order of demolition and the corporation may proceed. And if your lordship
Bring it on record.
If your lordship is
bring that on record.
If your lordship it is there on record, we have filed. It is not our duty. It is for the department, and it is appearing as can 1 in the list. We are of the view that the matter is there. Otherwise, it could not have been listed. Had we knew, but in any case, lordship may kindly keeps it of Monday, and kindly directs the department in the same heading. Kindly not passes any order, in that will be construed that lordship has been pleased not to extend the interim order.
Let the can be listed. Can pehle kar do.
Kindly keeps it on Monday.
Let the can no Monday. Let the can be listed on Wednesday. No urgency.
So other orders, my lord, lordship may kindly consider on that day also.
You file your report, we'll finish it off. If you 1 week, you'll file your affidavit in opposition.
The report on affidavit, Milord, of a week.
Just take down. A report in the form of affidavit shall be filed within 1 week. Exception to the same within 1 week thereafter. Full stop. Let this matter be listed after 2 weeks.
But in that case also,
in
it
the
will be
meantime,
construed that it is not been extended.
In the meantime, the stay granted wide order dated. What is it?
12 September
12 September
2024.
2024. And further extended by order dated 11/11/2024 for a period of 6 weeks is extended for another 4 weeks from today.
Deeply obliged.
Full stop. We'll finish it off. You get that? We'll finish it off.
Deeply obliged.
The dates I've written rightly, na?
Yes, sir. 12 September,
11.
Right.
11 September, no, 11 November.
11 November, 11 November.
11/11.
Yes, yes. 11 November.
I don't have the file with me.
Deeply obliged.
Number 11.
Well, I appear for the respondent number 228.
Well, I appear.
Can so and so is disposed of. What is the can number? Can in terms of can one is disposed of in terms of the above order. Extension देके उसमें can one का extension करके ना इसको dispose of.
That is exactly what I feel.
My lord, I appear for the respondent, principal respondent, but this matter pertains to group 6 service matter.
Actually,
It is wrongly.
it is
filed.
under the Kolkata Municipal
Learned
Corporation.
counsel for the parties. He's saying group 6. Are you disputing it?
Well, yeah, my junior has given me an impression. I also put that question to him that this is relating to the retail dues. Junior said it is under the Kolkata Municipal Corporation. KMD is operating under Municipal Corporation, therefore it will be a corporation matter. But instructions have been given from 2013, pension
you-
not paid. I have been given instructions that
Decide between both of you whether it is group 6, group 5, group 9. What is it?
it is a lordship's jurisdictional group. I say you lot. But it is very simple.
Learned counsel for the respondent state that the present matter pertains to group 6. Learned counsel of the parties state that the present matter pertains to group 6. Let this matter be listed before the roster bench, subject to orders of the Honorable Chief Justice.
এই তো 24
হ্যাঁ, ওইটা comply করেনি তো।
বললাম তো আমি সার্ভিস
Item number 12, my lord, I am appearing for the
Any other?
petitioner, my lord.
I am for the respondent municipality.
I am for the state, my lord. My lord, determined benefit matter, my lord. My lord, your petitioner was a sanitary inspector that the municipal respondent municipality, my lord. His service was approved in the year 1987, 1st December 1987, my lord.
Sir, I have to take the,
And retired from service on 28th of
sir, I
February.
have to take Port Blair matter. So we'll have these matters Monday onwards. There's a special bench I have kept. 12:45. Special bench I have kept for.
5 minutes, very short matter.
We'll have it on some other time.
Lord, item 14, I mentioned for extension. I am unwell, I could not make it to court. My lord will extend the interim order, is expiring, Lord, today. So, Lord, if my lord extends the interim order and keeps it on
Who's on
Monday,
the other side? Item 14, call item 14. Who's on
Lord,
the other side?
13 and 14. 13 is for implementation of the demolition order. 14th, I have challenged the demolition order. Mr. Sounak Bhattacharya was for the other side. But kindly extend the interim order, it is expiring.
I have objection, my lord. On
And
7th,
let us come back on Monday and Lord agitate the issues. Let it be there for 2 days. Let us agitate this, Lord, on Monday. I also could not go to court, Lord. I am not very well. Kindly extend it for a limited period. Let us come back. There is an order for filing affidavit. They have not filed their affidavit also.
Have you filed the affidavit? Or
No, nobody has filed the affidavit. 25th February order, my lord, kindly sees 18238. 25th February, the interim order was for 2 months and there was direction for filing affidavit. In the second page, my lord may see of that order, no affidavit has been filed. My lord may extend it for a limited period, my lord. Let them file their affidavit, which we can, Lord, finally, Lord, argue the matter and Lord, your lordship may pass the necessary orders. 25th February order, Justice Chondo extended the interim order. See in the second page, in the light of the foregoing second paragraph, foregoing the impugned demolition order shall remain stayed for a period of 2 months. 25th February, it expired on 25th of April today. And my lord, last paragraph, party is permitted to file affidavit in response to the allegations in the meantime. No affidavit has been filed, my lord.
file your affidavit, sir.
Yes, let
my
them
lord,
file it.
affidavit is ready. They
Let them file it. Let them file it.
You are
Let them
appearing
file.
Asansol.
No, I appear for Asansol Municipal Corporation.
File your affidavit.
Definitely.
You are appearing for the private party.
I am
Yes.
for the
I am for
petitioner.
the private response.
I am for the lead petitioner, item number 13.
Lord, in
For
my lord, in item 13, he wait for execution of the demolition order. 14th, I challenge the demolition order.
So this order of stay is in item 14.
Yes, both the matters were heard together. Kindly have a look at it, the order.
Item 14, just take down. This court-wide order dated 25/2/2025 had granted interim stay for a period of 2 months.
2 months, my lord.
The said interim order is extended further for a period of 1 month.
My lord, I'm so grateful.
Full stop.
But what I'm submitting, my lord,
The learned counsel for the petitioner has filed his affidavit in opposition. Item 14, yeah. Affidavit in opposition. Same is taken on record. Do you want to file your exception?
Yes, yes, my lord.
Learned counsel for the petitioner seeks 1 week's time to file his exception to the same. Full stop. In item 13, note down, learned counsel for the respondent. In item 14, the stay has been granted.
Yes, my lord, in 14, the corporation will also file affidavit.
It's fine. Item 13, learned counsel for the respondent corporation seeks further time of 2 weeks.
3 weeks.
Why 3 weeks? You have already taken so much time, 2 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter.
My lord.
List after 3 weeks. Both the matters list together. After
Lord, not only one indulgence, the corporation should file affidavit in 14 also. They have not filed affidavit in 14 also. So similar order may be in 14 also.
And only in 14, because that is, they are challenging the order of bill or demolition.
All right. Item 14, maybe like though
Because 13 is for implementation.
the corporation shall file his affidavit. That also you have to file your report.
Yes.
14, affidavit in opposition, 2 weeks. Corporation, Asansol Municipal Corporation seeks and is granted 2 weeks time to file their affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 3 weeks.
And the interim order is for 4 weeks, not that your lordship has extended.
Interim order is for 4 weeks.
my lord, only one submission, my lord, can't fix a date, my lord.
After 3 weeks, that's the date your lordship has fixed.
Any problem? No. Okay. After 3
Lord, I'm so grateful to your lordship for allowing me to appear virtually. Lord, I'm so grateful.
Item number 16, lordship is coming back after this.
I am appealing on behalf of the Bhatpara municipality. No copy of the has already been served. No copy served upon
This
the
is very
municipality.
important because tender, my lord, notice has been published. And I have challenged the show cause notice previously, my lord, blacklisted, that has been quashed. And thereafter blacklisted, that has been quashed. And thereafter there was a direction to, my lord, initiate show cause notice within 7 days. That has not been done. Now, my lord, the Noihati municipality has published e-tender. These people are, my lord, discouraging me to participate in the said proceedings. Though, my lord, the Chandanagar Municipality Corporation has not passed any final order, show cause notice is there, showing that show cause notice they are trying to prevent me, my lord. Only I am seeking protection.
I am appealing on behalf of the Bhatpara municipality.
The other municipality.
No copy of the.
We have effected service. I undertake to give him a copy. Only, my lord, limited protection. Let it be on Tuesday, on Monday or Tuesday. My lord, that regarding, my lord, that stay of so-called notice, my lord.
No stay, sir.
My lord, because of otherwise I cannot take part.
Mr. Chakravarti, that's why I will allow you to participate. Show me the file.
Kindly allow me to participate. But this much, my lord. Then kindly hear this matter and do whatever lordship will decide.
I am not instructed till.
This is not his concern.
When is the last date?
Today itself. This is not their concern. They are the Bhatpara municipality. Notice issued by the Noihati municipality.
It is e-tender.
They made party to the Bhatpara municipality.
It is e-tender, right?
Lordship.
So you can participate. Who's stopping you from participating?
My lord, the Noihati municipality people are discouraging me to take part.
Doesn't make sense, sir.
So that is why, my lord,
Participate. We'll take the matter.
My lord, one line order may kindly be given, my lord, limited protection.
Nobody is stopping you from participating. I don't hear it from anybody who's stopping you from participating. You participate. Whether that is granted, not granted is a different.
My lord, one line order may kindly be given, my lord.
If they don't allow you to participate.
In Tuesday, Monday or Tuesday, lordship thinks it fit, my lord, kindly quash it. Only one line protection order may kindly give.
No, these one line orders, I know what it can do to everything.
Lordship.
I will not pass any one line order. If they don't, you mention it on Tuesday, we'll hear it.
Not out of turn, I have mentioned, lordship was kind enough to fix it.
Give direction upon them to serve copy upon them.
Serve a copy on everyone.
I have served. Once again, I will serve. They have no stake.
Now,
why they are raising their voice, I fail to understand.
Hati also, you serve them.
I will serve, my lord. Only, my lord, I know, my lord, the special
Lord,
bench is there. I'm sorry, my lord.
Lord, my lord would be coming back, Lord, for
I have a
appellate
special
session.
bench.
My lord, I'm so grateful, Lord.
Call the person.
Lord, I am unwell. Item 29, somebody will pray for an accommodation. Lord, kindly, if possible, Lord, accommodate.
No, sir, not right now.
Very well.
I'm already late.
But after 2 p.m. this list will continue.
No.
After 2 p.m. nothing.
My lord, in the evening, my lord, the notification disability did not permit me, my lord, to participate. Lordship will protect me, my lord, and mandate you.
My lord.
Where is the person?
Special bench. Judge have a special bench.
My lord. May I be permitted to mention, my lord? Item number 30.
No, sir, not right now.
Much obliged, my lord, much obliged.
Tender, madam.
Sorry.
Fourth clear matter, item number 1.
My lord, I beg to appear for the respondent,
Lord,
my lord, in this matter. My lord, I beg to appear for the respondent.
I'm for the petitioner, my lord. I'm for the petitioner.
In terms of the last order,
Screen on karo.
Lord, if my lord sees the last order of 6th of March 2025.
Just a minute. Hold on.
Well,
Yes. Oh, Mr. Satadaru.
my lord, in terms of the last order, if my lord sees, there was a special officer was appointed, my lord, to submit a report. My lord, if my lord sees the order of 6th of March 2025.
Lord,
My
the
lord,
order is annexed in my CAN application.
No, before extension, where is the, my lord, may kindly see the order first.
I'm showing the order. Order is annexed in CAN application.
Yes.
So, my lord, the report, we don't know. We have not been given a copy, but if it is a sealed covered, my lord may consider if the report says that it is unauthorized construction, then the matter, in my humble submission, then, my lord, there is no question of extension of interim order, my lord, if the report is not against them, my lord. Otherwise, my lord, we are ready for arguments. We'll have to consider the report, my lord, in case the report is against the municipal corporation.
Yes. Let me see
Because
that.
I'm told it was submitted in a sealed cover, my lord.
Yes, see, I'm getting it open. You have done encroachment, sir. The
My
report
lord, I do
says,
not know, my lord, what is written there, my lord. I have to see it. But my lord, there is an allegation to me, but that I have recently installed rolling shutter. My lord, in the record, my lord, I had disclosed that it was installed after obtaining permission from the municipal council. My lord, the special officer, my lord, if your lordship looks at the order passed by this honorable court, my lord, the learned special officer was appointed to ascertain or determine with the help of surveyor whether the rolling shutter was recently erected or it was installed way back. My lord, that is our pure fundamental case here, that this rolling shutter was installed by us after obtaining permission in 2011. Not only that, my lord. So far the allegation of encroachment is concerned, my lord, I have produced the record. There are 3 orders passed by the authority in 2014 as regards to other shop owners, shopkeepers. Those are tenants in the same market, my lord, where they allowed them to addition area. And my lord, I have also filed an application, my lord. I'm ready and willing to comply with whatever the terms they put in. My lord, kindly see.
Satadaru.
My lord.
Let a report be given to
No,
us.
my lord, if my lord, if the special officer's report says, my lord, that there is encroachment, then my lord, then kindly see, my lord, the impugned order 3rd March 2025 passed by the Secretary Municipal Council, which is the last annexure, my lord.
My lord,
The order is well reasoned, my lord. My lord, that was an interim. At the interim stage, the court felt that, my lord, that a special officer needs to be appointed, but that's not a final view, my lord.
Go through with the report, my lord, once. So it will be.
It's a well-reasoned order, my lord. If they are agreed,
if required, my lord, I will file exceptions, my lord, if I find something, my lord.
Why is the report in sealed cover?
My lord, I don't know, my lord. The special officer, there is no direction to a sealed cover, but
Who's the special officer?
Yes.
He is not present, my lord. He is not.
Port Blair, advocate in Port Blair.
That happened, my lord. My lord,
Has he given a copy?
No, my lord.
All right.
Let us see the report once.
Let them get a copy of this.
My lord.
The special commissioner is directed to provide a copy of the report. Dated 1/4/2025 to the petitioner. Full stop.
My lord, we may be also provided, my lord. We also haven't received.
To the petitioner as well as the other contesting parties.
My lord.
You don't want to file an exception, Mr. Satadar.
My lord, I am not, if my lord, from what has fallen from your lordship, my lord, but we have not seen the report, my lord. So, my lord, in case
party seeks 1 week time to file their exception to the said report, let this matter be listed after 2 weeks. In the meantime, the interim order dated, what is the date of the order?
6th March 2025.
March 2025 is further extended for a period of 3 weeks. 4 weeks. 4 weeks. Let this matter be listed after 2 weeks, also 3 weeks. Extended for 3 weeks. We'll decide it. 3 weeks.
My lord.
My lord, same orders can be passed, my lord. The next 2 matters, my lord. All
Yes,
our common issues are involved.
All 3 report should be submitted. And please ask the special commissioner to provide a report to everyone.
Yes. Write a letter, my lord, today itself.
Yes.
My lord. My lord.
My lord, affidavit of service, maybe.
Affidavit of service is taken on record.
Grateful.
One thing. And this complete encroachment, let me tell you. You have put tile, you are the richest man in the shopping area. You have put tile.
My lord, I will take instruction, my lord.
You have covered the entire passage.
My lord, let me go through with the report, my lord. I will take
I have gone through the report.
Yes, my lord.
The report is sacrosanct. It is by a special commissioner. Exception you can file, but the special commissioner has no interest. It is conducted with you, with the surveyor,
Yes,
with
yes.
the
Parties
officer
were-
concerned.
Parties were there.
Everybody was there. So you're well aware of what you have done. Nobody should come and tell you what you have done. You know what you have done. So better put your house in order rather than fighting it out.
My lord, I will take necessary instruction.
Man.
You're wasting the time of the court. Then I'll also impose cost on you, because after knowing all this, if you're still wasting the time of the court, then you should be penalized for it.
Understood. Understood.
Man. Man.
I'm submitting.
কত কত দিনে ছিল ওটা?
After recess, বসবে না দাদা?
ওরা বলতে পারবে, আমি জানি না। হ্যাঁ, ওটা হলো তো।
বলে গেল, তুই ওদের বলছিস ওই ভদ্রলোক আসুন।
কিন্তু ভাই লাগবে। বুঝবে তো। আমাকে এটা দিতে হতো না।
উনি মুখ দিয়ে বলবেন না, হ্যাঁ বলবেন, অফিসিয়ালি বলবেন।
সেকেন্ড হাফে বুঝবে?
शायद सेकंड हाफ नहीं टूटेगा।
ওই যে বড় ভাই।
হয়েছে